All right, well, with that, I think we better get underway. So welcome everybody to today's webinar hosted by the ShipSource Oil Pollution Fund. Our title today is An Introduction to Compensation for Fishers, Aquaculturists, and all involved in related activities. So a quick introduction of myself first. My name is Ryan Gauvin. I'm a lawyer here at the fund, part of our very small but very busy legal team. And you'll get a greater sense of what I do here at the fund as the webinar goes on. But I want to stress that our major emphasis today is on claims submission. So that'll be the main focus. The webinar is sort of geared to be an introduction to our viewers, our participants, and I understand that we have potentially over 100 people registered for today's webinar, which I think is an in-house record for the fund. We've done a few of these in the past and turnout has always been good. Today, we're looking at particularly good turnout. So before we get started, one of the things I want to point out is that we're going to have a question and answer mechanism open the entire time that the webinar is running. But given that we've just got an hour together today, we're going to, for the most part, proceed with a presentation that's about 45 minutes. And at the end, we're hoping to have a bit of time for Q&A. Of course, if we don't get to all the questions, and we expect a lot of questions, we encourage you to ask questions. If we don't get to them all, we will answer as best as we're capable your questions in writing and post them to our website, hopefully this week and perhaps next. So with that, let's get started. Okay. A final note, we're going to post not only the Q&A results, but also these slides to our website, as well as a video recording of today's webinar as well. So here we are. Quick overview of what we're going to be doing today. I want to identify who our intended audience is for this webinar. As I've said, this is a more focused webinar than any of the ones that we've offered in the past. So it'll be very important to sort out who we are speaking to. This will align with the audience, the intended audience for your handout today, which is our compensation handbook for all those involved in the fishing sector and the aquaculture sector as well. Next, we're going to discuss what the ShipSource Oil Pollution Fund is and what it does. Third, we're going to talk about how you can access compensation from the fund. Fourth, how does the claims process work? This is very important because we anticipate that a lot of our audience might be potential claimants to the fund in the future. Okay, so on to our first topic. This is the audience of the webinar. Who are you? Well, you know who you are individually, but who are we talking to collectively today? Simple question. Are you engaged in any of the following activities on or near a body of water in Canada? Well, fishing, of course. 2, aquaculture and mariculture. Usually we use the phrase or the word aquaculture in Canada, but in the international context, sometimes we see the second word here. Harvesting, well, this might be harvesting of any aquatic produce, whether it's clams or seaweed or anything similar. The hunting of animals that are coastal or near a body of water. Processing, preparation, packaging, and distribution of marine products, whether those might be fish or anything similar. Tourism and hospitality related to the fisheries sectors. Management of fishing harbors, and finally, and perhaps, well, certainly very importantly, subsistence living. Of course, we have all kinds of coastal communities in Canada that depend not only on marine produce for economic reasons, but also for cultural reasons. And of course, First Nations communities will fall into both categories, subsistence and economic reliance on marine sources. Okay, so let's start with a very small number and we'll discuss the significance of this number, 0.7%. Why are we doing this webinar? Well, 0.7% of the compensation paid from the ShipSource Oil Pollution Fund in its 30-year history has gone to those in the fishing sectors. Now, I want to stress that the fishing sectors, today when we mention that phrase, we're talking about the categories of person who we identified on the last slide. So 0.7% represents only about $170,000 over the course of 10 different claims that were filed with the fund over a 24-year period. Frankly, this number is too small. We recognize at the fund that there are probably many people in the fisheries sectors who, for whatever reason, whether they're not familiar with the fund or whether they just simply haven't had the opportunity to put together a claim, ought to have received compensation from the fund. So why are we doing this webinar? Well, we want to expand the knowledge of the fund, and we want to reach out to a broader base of potential claimants, because this number should probably be higher. People should have more access to the fund, people in the fisheries sectors. Now, the secondary reason for putting on this webinar, 1 in 4, another statistic for you. 1 in 4 in 30 years, 1 in 4 vessels that cause incidents of ship source oil pollution fund that result in claims to the fund have been commercial fishing vessels. Now, this is a significant proportion, but one of the things we want to stress is that we at the fund see vessel owners as our partners in many ways. Commercial fishing vessels tend to be well insured, and owners of commercial fishing vessels tend to be very responsible, whether those owners are individuals or corporations. So in Canada, there's responsibility and there's liability on a ship owner to respond to a ship source oil pollution incident and to pay for any damages caused by that incident. Now, after we pay compensation to people who are affected by the incident, we turn around and we have to recover against the ship owner or the insurer. And when a vessel is well insured and operated by responsible people, we see a very, very high rate of return on that. We pay compensation to people affected and we see recovery. So this puts a bit of a positive spin on our secondary purpose today. We want to inform people in the fishing sector of this potential liability, but also emphasize that people in the fishing sectors who may be behind these spills are our partners as well. So what is the Ship Source Oil Pollution Fund? Well, the name tells much of the story, but we also have a few questions that are residual here, and we'll deal with those on the next few slides. We have a 30-year history. Over 30 years, we've published each of those years an annual report, and what we publish these online these days. We also publish them in print. What can you find in the annual reports? Well, all kinds of key statistics on our performance over a given year, the number of claims we've paid, the amounts that we've paid. You're going to find also some key legal and organizational milestones detailed in those reports. And finally, you're going to find, and probably most importantly, you're going to find references to summaries of incidents and claims that the fund has seen in a given year. Now, we cover so many incidents these days that we don't have room in our annual reports to detail them. So we publish our summaries online as sort of an appendix to our annual reports. Okay, the balance of the fund today is about $411 million. That sounds like a lot of money, and of course it is. What do we do with this money? Well, first and foremost, we compensate those who are affected by ship source oil pollution incidents. Secondly, and also very importantly, we make Canada's contributions to the International Oil Pollution Funds. Now, the IOPC funds, or the International Oil Pollution Funds, deal with tanker spills, and Canada has access to really significant compensation in the event of a tanker spill in our water. Now, of course, in our waters, of course, those spills are very rare, but it is very nice to know that there are several layers of compensation available. First and foremost, from the ship owner and its insurer. Second, from the international funds, the IOPC funds. And third, from the Ship Source Oil Pollution Fund. And that brings me to the second detail here, which is also very important. In 2018, Parliament lifted the per incident cap of compensation that the Ship Source Oil Pollution Fund can pay to claimants. Before 2018, the limit was about 175 million per incident, and today that limit is removed entirely. So there's no maximum to the amount that can be paid per claim per incident. Now, we've paid over 400 claims in our history, and this is a very large number, of course, but it's going up every year. We see it going up. This doesn't necessarily mean that there are more oil pollution incidents in Canadian waters. In fact, that number may be going down on an annual basis, but we may see more claims. Why? Because more people are familiar with the Ship Source Oil Pollution Fund. More people know how we work, and more people therefore have access to compensation. Finally, I should note that the $411 million there is made up of contributions from the oil industry in the 1970s. Contributions were stopped in the mid-1970s because the fund was considered fully capitalized. At the time, I believe the balance was in the $30 million range. We've been growing ever since based on interest that's credited to the fund on a monthly basis, but also from recovery from ship owners. And the levy on oil shipments can be reinstated by the federal government anytime if deemed necessary, essentially if the fund's balance appears to be at risk of depletion. Okay, our largest ever claim paid was $4.5 million, and this is a direct claim to the fund. This goes back to the 2015 sinking of a tugboat near Trois-Rivières in Quebec. It's a substantial amount, but of course, we could see larger claims in the future. Now, that said, historically, the majority of the claims to the fund are under $50,000. Okay, these are claims generally coming from the Canadian Coast Guard, where they respond to small-scale incidents. Now, speaking of small-scale incidents, the smallest claim we ever saw was $217.86. I believe it came from BC. There's no minimum claim. A lot of people will ask us, well, there's no maximum. Okay, is there a minimum amount that we can seek in terms of compensation from the fund? There is not. It's really just a question of whether or not it's worth compiling your documentation to file a claim to the fund. And we would venture that it almost always is. Okay, the fund is presided over by two independent administrators. Here we have them pictured. The administrator is Anne Lagarde, appointed in 2016, and Marc Gauthier is the deputy administrator. He was appointed in 2018. Now, between them, we have a wealth of experience. Both are lawyers, both have plenty of experience in the marine field. And our administrator comes from the private sector, whereas our deputy administrator comes from the public sector. So again, quite a lot of experience between the two. Now, before we move on, independent administrators, I want to stress that it's very important that they maintain a degree of independence. Why? Well, a court has to be independent because it has to be perceived to be impartial in its decision making. So there's a separation there between the fund and government, in part because government, the Canadian Coast Guard, as the primary responder in many cases in Canada, is our largest and most frequent claimant. Okay, so now you know who we are and where we came from and what we do. Let's talk about how the fund gets used in a little bit more detail. How can you access compensation from the fund? Okay, compensation from the fund is available when a ship spills or threatens to spill oil into Canadian waters. So, simple sentence, expands the name of the fund a little bit, but there may still be some residual questions here. For instance, what is a ship exactly? Okay. How do we define oil? That's also valid. And finally, how do we define Canadian waters? Well, let's discuss those items. First of all, I want to stress that ship in this context doesn't just mean large vessels and oil tankers, okay? Though we may see claims from very large vessels, they're in fact actually quite rare. The majority of our claims come from smaller vessels. This was a 2016 incident in Nanaimo Harbour in BC. Now, what you see around that vessel there, which is partially sunk, is a boom of some kind. It's probably sorbent boom designed to soak up oil pollutants that get discharged when a vessel like that sinks. So, though we're called the Ship Source Oil Pollution Fund, you might think of us as the Ship and Boat Source Oil Pollution Fund. Big and small, all are covered. Now, I should stress as well that this incident here actually involved two claims. There was a claim from the Canadian Coast Guard that oversaw the response, but there was also the Nanaimo Harbour Authority, which was very closely involved as well. Fishing vessels also qualify as ships or boats under our regime. This was a 2017 incident in Newfoundland where the owner of the vessel was very responsible and undertook almost all, in fact, probably all of the measures that were required by the Canadian Coast Guard, whose response was very limited to just monitoring of the owner's measures. Here, we note that we also cover spills and threatened spills from tiny pleasure craft. Here, I think we have a very small sailboat that went down, and around it, again, you'll see the sorbent boom. This sailboat had oil on it, and any amount of oil is obviously undesirable in the water. So we would cover measures taken, whether by the Canadian Coast Guard or anyone for that matter, to prevent and mitigate the oil pollution damage from a spill on that scale. And finally, even this would be covered as a ship. Okay. What is this? I believe it's some kind of fishing vessel on the Great Lakes. But the point here is that anything that navigates on water is covered as a ship or a boat. And regardless of whether the navigating object is self-propelled or not. So why is self-propelled so important? Well, barges are covered. They're towed by tugs, other vessels, but they also qualify in and of themselves as ships under our regime. So we've seen claims stemming from tugs. In fact, our largest ever claim that was paid out was from a sunken tugboat. But we also see claims from barges, and these can be significant claims. We can also see claims from passenger vessels. Again, to stress, anything that navigates is covered as a ship. Also, an oil spill is not required. So are we talking about proactive measures to set up a response capability? Here, no. We have other mechanisms in Canada that fund that. Most of that is funded through industry and response organizations, which you may be familiar with. Here, what we're talking about is where we have a marine casualty or some sort of marine occurrence that results in a risk of an oil spill. So we might get a responder such as the Canadian Coast Guard, or occasionally a small community or a harbor that may be the first on scene that has an opportunity to take measures. Well, the cost of those measures, to the extent that those measures are reasonable, are compensable from the fund. Okay. This is also an interesting and very useful item. Mystery spills are compensable too. What is a mystery spill? Well, a mystery spill is a ship source spill where the ship that it causes the spill cannot necessarily be identified. So we have two examples of this. Perhaps you wake up in the morning and perhaps you have a coastal property or you're working on a dock somewhere and you see an oil slick on the water. And you look around and there are no boats or ships visible. Well, it's clear that the spill came from somewhere. It's not necessarily clear where it came from, but if the evidence supports that it came from a ship, this is what we have. We have a mystery spill. Alternatively, imagine we have a sheen on the water in a busy harbor with lots of craft around. Well, it's not always easy to identify which of those vessels or boats the spill came from, but if it looks as if the spill came from a boat, it's compensable. Now, I keep saying it has to come from a boat. How do we know exactly if it's not clear which vessel it came from? Well, in general, there may be certain factors that point to it. The type of oil is relevant. All of these things are relevant. Now, do claimants have to prove to us that the spill came from a ship or a boat? No, that's not on claimants. We encourage claimants to do that if they can. For instance, if there's any media reporting of the spill, they could provide that to us. They could inform us of it. If there's any government documentation of the offending vessel, by all means, provide that to us as well. But I want to emphasize that it's not on claimants to prove to us that the spill came from a ship. Rather, it's on us to be satisfied on the evidence that it's more likely than not that the spill came from a ship. Okay. What is oil exactly? Basically, it's any mineral oil or hydrocarbon. So we have a list of a few examples on the screen here. Anybody involved in the marine industry is going to be familiar with all of these. I want to emphasize as well that oil contaminated water is also covered. So if we have a small vessel or a large vessel that sinks and there's oil contamination throughout, the water ingress that might be contaminated with oil will probably have to be pumped out and removed, and that process would be compensable by the fund, even though oil might make up only some percentage of the water inside the vessel. I should stress that potential cargo like vegetable oil would not be covered by the fund. This is because it's not a mineral or hydrocarbon oil. Okay, finally, we were asking, what is Canadian waters? How do we decide what constitutes Canadian waters? Well, generally speaking, anything on the coast up to 200 nautical miles away is considered Canadian waters. In legal parlance, this is the exclusive economic zone of Canada. This gets a little bit more complex the closer you get to a marine border, and we'll talk about a few examples there. Now, there's an asterisk there as well, because it's possible for the fund to pay compensation even if a spill doesn't occur in Canadian waters. If it occurs outside Canadian waters, and there's a possibility that the oil sheen might move into Canadian waters and measures are taken as a result, compensation can be paid. Okay, so we're going to push a poll to everybody right now, a little quiz in fact, and you should be seeing it on your screens now. Essentially, we're putting a fact pattern to you, and we're asking you for your opinion on whether compensation would be paid. So the facts are this: you've got a large fishing vessel in the course of refueling at a dock somewhere in BC. And during the course of refueling, oil ends up in the water. So in your opinion, based on what you've heard so far, based on what you know, are those affected by the spill eligible to submit a claim to the fund, and would they be eligible for compensation from the fund? We've got three choices: yes, no, or this cagey response of it depends. So go ahead, and we'll talk about your replies in a moment. I'll give you about 20 seconds or so. Okay, we'll give you a few more seconds to get your answers in. Okay, so we've got the results. Okay. Sorry, Bernice, I'm not, yeah, you can close it. All right, so it looks as if 83% have responded. That's great. And our responses, I'm not able to see them for some reason. Let's see. Okay. Well, we'll talk about the answer. The answer is it depends. The answer is C here. Why does it depend? Well, let's think back to the name of our organization. We're the Ship Source Oil Pollution Fund. So the real question here is, we have a ship involved. That's great. We can put a check mark in that box. We have Canadian waters. Of course, a dock in BC is Canadian waters. But what's the crucial element that might be missing here? Did the spill actually come from the ship, or did it come from shore? And this is going to be a technical question, unfortunately. It would depend on where the source of the spill was. If the oil or fuel was entering the vessel and then coming out because perhaps it had been overfilled, that's almost unquestionably a ship source spill. On the other hand, if we're looking at a shore-based spill, let's say something happens on the pump side on shore, this is probably not compensable from the fund. This is outside of our jurisdiction. Okay. Let's move on. I should also stress that we cover not only coastal waters, but inland waters, including lakes, rivers, and canals. Now, how does the fund actually operate? How does the claims process work? Well, we have a polluter pays concept in Canada that we've talked about to some extent already. How do you, as somebody affected by ship source oil pollution, how do you access compensation? Well, the first option might be to approach the ship owner. The ship owner in Canada is held liable with strict liability. What does that mean? Well, fault is not required. We don't have to show, or you as the claimant don't have to show that there was negligence or any other kind of fault on the ship owner's behalf. That sounds easy, but of course, you might have to initiate court proceedings, and this can be costly, it can be uncertain, it can be time consuming. So there's an alternative. Instead of going to court against the ship owner or for a larger vessel, its insurer, you can submit a claim directly to the fund. We'll talk about how that works in a little bit more detail shortly, but submitting a claim directly to the fund allows you to bypass the whole court process. Now, I should stress that in the indirect claims context, if you submit a claim in court, the administrator and the fund will automatically become a party to that court action, meaning that the fund is there to pay over and above whatever the ship owner may be ordered to pay by the court. There's some complexities here. It's possible that the ship owner might have a defense in order to avoid liability altogether. These are very unusual, but there are three streams of defenses. Essentially, war or an exceptional natural disaster of some kind causing the spill may allow the ship owner to evade liability. Sabotage by a third party or negligent maintenance of navigational aids. Now, these are unusual, these defenses, but if the defense is made out and the ship owner is not found liable, the Ship Source Oil Pollution Fund will be liable to pay instead. So compensation is always there from the fund. In the indirect sense, it's there as sort of a safeguard, and in the direct sense, it's there initially without any requirement for court proceedings. Okay. Now, an overview of what we actually compensate at the fund. This is important. It's actually quite a broad range of potential damages that we compensate, but let's detail them to some degree. First off, we have property damage. This would include any physical damage to property caused by oil contamination. Okay, some examples. In the fishing context, we might have soiled gear or other equipment that might need to be cleaned, repaired, or replaced. We have contaminated fishing boats, docks, wharves, or aquaculture facilities potentially. Third, oil-contaminated catch or other products. This would be considered property if it's in the possession of the fisher or the aquaculture facility, and potentially compensable if these products are lost. Okay, so property damage, one of the guiding principles here that we look at is the concept of reasonableness. Basically, the fund can only put claimants back in the position that they were in before they suffered damage. So we're not going to necessarily replace a wooden dock with a steel one. That's not what we would compensate. However, we are able to compensate like for like. So if it was necessary to clean a soiled dock or soiled equipment, to the extent that the cleaning measures were reasonable and the costs associated with them were reasonable, we can compensate that. Now, we get into the discussion of cleaning versus replacement. Well, this is where reasonableness comes in. If it costs an awful lot of money to replace something that can be cleaned for much less money, it's probably more reasonable to clean it. And that's where our compensation would end most likely. Okay, lost wages or profits in the economic loss realm. Examples for our audience: fisheries closures resulting in reduced yields or decreased demand. And this would be following an oil pollution incident. This would also potentially cover a decision not to fish in a certain area because it may be uncertain at that time whether contamination is causing any issues with potential marine life. Again, subject to reasonableness. What else? Increased overhead costs associated with reaching new fishing areas would also be covered. Let's say you have an area of contamination resulting in a fisheries closure, but there are alternative fishing grounds that can be reached. Well, the costs associated with reaching those alternative grounds would be covered by the fund to the extent that they're reasonable. Finally, an unsellable catch or other products due to contamination. We've talked about this already in the property loss context, but it might also fall here. We're talking about lost opportunity to profit here. So don't think too much about which category your loss falls into necessarily, but note that if you've lost a product, the damages associated with that loss are going to be compensable. Okay. Subsistence, recreational, cultural, ceremonial losses. This is also covered by the fund. Okay. It may not be readily apparent that these losses are economic in nature, but in fact they may be, and compensation in an economic sense may not be may not restore claimants absolutely perfectly to their original position, but it can come close. What are some examples here? If you're fishing for subsistence purposes or even for recreational purposes, and you're not able to do so, some form of compensation will be payable to you. Okay. Other examples: decreased availability of animal skins or fish used in traditional ceremonies. Again, if an oil spill results in a lack of access to these resources that were enjoyed and depended upon prior to the spill, compensation will be payable. Finally, cost of replacement of these items. So this is the remedy essentially. If a group of people, whether a coastal community or a group of fishermen, is depending on a certain element of marine life and it can no longer access that reasonably, replacement of that item will potentially be payable from the fund. Okay, preventive measures. We've talked about this in some detail already. We're talking about the cost of reasonable measures taken to prevent, repair, remedy, or minimize oil pollution damage. So here, remember that an incident is required. We're not talking about spill preparedness here. Now, what are some examples? We've talked about sorbent materials such as boom or sorbent pads. And it's important to note here that those sorbents might not just be deployed around a sunken vessel, but they could also be deployed conceivably to protect certain sensitive resources, such as harvesting grounds, clam beds, or beaches. Okay. I should stress as well that anybody can take preventive measures. It's not just the Canadian Coast Guard, it's not just response organizations or ship owners. If you happen to be the first on the scene, you look around and you see that measures are needed and you take those measures, it's possible to receive compensation from the fund. Okay, environmental reinstatement. This goes a little bit to preventive measures, and there's also some concepts of property damage potentially woven in here as well. But essentially what we're talking about here is it's recognized in Canadian legislation that an oil spill can have a really adverse effect on the environment, whether in the short term, the medium term, or the long term. Well, any measures taken to enhance environmental recovery, whether that recovery includes repopulating certain fish species or other clams or so on, this could be compensable. Environmental reinstatement costs are compensable even if they haven't been taken yet at the time that the claim is made. If there's a clear commitment to make those measures, this could be compensable, even if it's after the fact, after the claim has been filed. Now, I'll stress, usually it's a government agency that will take measures like this, but conceivably, it could be any claimant with a delegated authority or a closely vested interest in the environment in a particular area. Okay. And finally, we've got special losses such as future losses and losses outside of Canadian waters. Now, we have a dedicated manual on this topic, and I'm not going to dwell on it too much, but suffice to say that certain groups of people who are closely linked with the fishing sectors might be eligible to receive compensation for losses that haven't necessarily been suffered yet. In addition, certain of those groups might be eligible for losses suffered outside of Canadian waters. We'll talk about that a little bit more on the next slide. But examples of this, well, for many people in the fishing sectors, a stop in business can mean really dire consequences for the business. If there's a fishing ban following a spill, the economic need is immediate. So this process recognizes that certain claimants might be able to receive interim funding from the Ship Source Oil Pollution Fund. So if you fall into any of these categories, if you're an individual who earns an income from fishing, aquaculture, or the harvesting of marine plants, if you're an individual who earns an income from handling fish on shore, an individual worker in a fish plant, including supervisors and managers in small plants, you're an individual who fishes or hunts for food or animal skins for personal use, consumption, or the consumption or use of your dependents, and finally, if you're an individual, corporation, or other legal person, such as a partnership perhaps, that earns an income from renting fishing vessels, you might be eligible for this special compensation. Now, what we suggest is that if you're filing a claim with the Ship Source Oil Pollution Fund and you might fit into one of these categories, you should self-identify. This gives us the opportunity to assess whether there might be this additional eligibility for compensation. And it gives us an opportunity to determine whether that compensation can be paid. Okay, when do you submit a claim to the Ship Source Oil Pollution Fund following an incident? The general rule here is that if you've suffered damages, you'll want to submit your claim as soon as possible. This allows you to present the best possible evidence to the administrator. It also allows you to ensure that you remain eligible, because we have something called a time bar or a limitation period that's essentially a deadline for when you have to submit your claim. If you miss that deadline, you may still be able to receive compensation, but it might get more complicated. So ask yourself, was there a spill? In most cases, if you're claiming for damages in the fisheries sectors, there will have been a spill. Then you can rely on a 2-year deadline following the date that you suffered damages. To be absolutely safe, we would recommend submitting your claim within 2 years following the incident. Now, if there was no spill, you may have up to 5 years, but this gets quite complex. So again, we would emphasize that you should submit your claim as soon as possible, ideally within the first 2 years following the incident. Now, I should note that this is for direct claims to the fund only. If you miss either of these 2 limitation periods, you might still have success if you file a court action against the ship owner. Now, of course, in that circumstance, this is the indirect claims model we talked about earlier. The administrator, the Ship Source Oil Pollution Fund, will be involved as a party in that court action, and you will be entitled to compensation from the fund to the extent that the ship owner is not liable to pay or is unable to pay. But The direct claims process is a much more streamlined process. And as a result, there are stricter time limitations there. Final thing I should note is that if you suffer damages that appear to be ongoing and that 2-year deadline is approaching, what do? Definitely submit a claim within the first 2 years. Be very clear that you're still suffering damages. Fisheries closures might be ongoing. At that point, the fund will be in a position to assess what can be done. Particularly if you fall into one of the special claims categories that we discussed earlier, you might be eligible for compensation that takes into account losses after the date that you submit your claim. Okay, claims assessment overview. How does our assessment process work? How do we evaluate claims? What standards do we use? We've talked about some of these already. First and foremost, no double recovery. If you're paid by the ship owner and you recover in full, you have no eligibility to seek compensation from the fund. It's a pretty simple concept. You can't recover for your damages twice. Number 2, claimants must provide evidence of their damages. Well, what might this evidence look like? We'll talk about that on the next slide. 3, damages must be caused by oil carried on board a ship. Again, we've discussed this already. Ship source oil pollution fund. It gets a little tricky if you're refueling, but generally speaking, it'll be quite clear, unless it's a mystery spill. 4, reasonableness. We've talked about this as well. This is the concept that the measures taken or the cost of replacing damaged goods should not vastly exceed the loss in question. So if you're taking very expensive measures to avert a minor loss, this may not be considered reasonable. But if there's potential for significant damage, or the damage isn't necessarily easy to anticipate, if it's not clear how much oil is on a sunken vessel, for instance, this will be taken into account. It's very important to note that with reasonableness, hindsight is not a factor. So what we focus on is what is known by the claimant who's taking measures at the relevant time. That's why evidence is so important. Finally, claimants should make efforts to minimize their own damages. A quick example of this in the fishing side is if there's a fisheries closure, let's say, in a particular area, but there might be opportunities to fish elsewhere, there's an obligation on claimants to take those opportunities into account, those alternative opportunities into account. So if fishing shuts down altogether and the claimant is not necessarily using those opportunities, the most that the fund could reasonably pay might be the extra cost that would have been associated with reaching those alternative fishing grounds. Okay, finally, evidence in support of a claim. Every claim should have a narrative that describes what happened, what was done in response. Ideally, the narrative should tie in the other evidence submitted with the claim, which might include photographs with captions and date stamps. Correspondence, this might be with other responding entities like the Coast Guard or other government entities, or even the ship owner. Contemporaneous notes, very important to record decision-making at the time. Why? Well, again, we're not based on hindsight here. Our assessment process is focused on what was known at the time, because responders and other people affected can only make decisions based on what they know, the best information they have at the time. Invoices, receipts, appraisals, surveys, reports, studies, all of these things can help to inform and support a claim for property damage, economic loss, preventive measures, etc. If you're claiming for economic loss, documentation of past and current financials and yields is also very important. So I want to stress as well that economic loss damages are compensable even if the claimant, let's say you're a business owner on the coast, a hotel, let's say, or a sport fishing lodge, even if you don't suffer any physical property damage, you may still be able to receive compensation from the fund if the spill caused economic loss, meaning your business suffered as a result of it. Okay, how does the claims process work? We'll move quickly here because we have good claims manuals that describe this in some detail. this is a graphic that we include with our claims manuals and gives you sort of a conceptual idea of how the claims process works. 2 points that I want to make. The assessment of a claim, and this focuses on things like, was the spill ship source? Were the measures taken, the costs incurred reasonable? The administrators make the ultimate decision, but sometimes they're assisted by people like me, lawyers at the fund, but also marine experts who we employ. It's important to note, though, that the ultimate decision is made by the administrator. When that decision is made, an offer of compensation goes to the claimant, and the claimant can either accept that offer of compensation within 60 days or appeal it to the federal court if the claimant is unsatisfied with the amount that's been offered. Okay, after compensation is paid to the claimant, what happens? Well, the claimant basically walks, compensated, hopefully happy. What do we do at the fund? Well, this is where the second element of our mandate comes in. We become subrogated, which means essentially that we take on the rights of the claimant legally and obligated under the statute that governs what we do to take all reasonable measures to recover from the ship owner or any other liable party, which might even include the international funds. So this is another important part of our mandate, and this is one of the things that ensures the health of the fund and protects the balance of the fund. So it might be necessary for you to be involved as a claimant in that process, whether you have to make a formal legal statement or not. But the emphasis here is that good documentation of a claim helps you as the claimant, increases your chances of recovering in full, but it also helps us at the fund, and it helps Canadians in general because it ensures that the polluter is more likely to pay. Okay, 3 options for submission of claims to the fund. 3 different claims streams. We've got the general claims stream, which is where most claims will fall. Most claims will be eligible under this process. We've described it in some detail. We've got the expedited process for small claims. In short, this process is for claims of $35,000 or less. Also, remember we talked about economic loss where there's no property damage in the equation. Well, this kind of claim is not eligible under the small claims process. That kind of claim would have to be submitted under the general process. So for those in the fisheries sectors, there may be some limits to keep in mind on the small claims side. Finally, the special loss claims mechanism. And this is seen as supplemental to the general claims process. And again, if you fall into one of the categories of persons who might be eligible for compensation under this stream, we encourage you to self-identify to the fund. Okay, a few very brief notes on the small claims process before we get to our Q&A process at the end. So I've overclicked here. Let's see. Submit your small claim not exceeding $35,000. Well, the initial assessment is abbreviated in a sense. The documentation that you have to submit is not as extensive as it would ordinarily be. So assessment is basically focused on eligibility. Was the spill from a ship? Was it likely that the damages were actually incurred by the claimant? If the administrator is satisfied, you'll receive compensation within 60 days of submission of your claim. The administrator becomes subrogated, meaning she becomes obligated to pursue the polluter for recovery. But she's also potentially obligated to go back to you and ask for full documentation. If that's done, and if it's deemed by the administrator that there's been an overpayment, certain amounts might have to be repaid. So for any individuals not necessarily familiar with the fund, it might be safest to use the general claims process. If you're claiming to the fund for the first time in particular, there's quite a bit of back and forth through the claims process. Where we have questions, we will ask you those questions. So I want to stress that the claims process is, generally speaking, a two-way process with claimants. There's quite a bit of communication sometimes. Okay, next steps. What do we have here? Our claims manuals and other publications are available on our website. There's a link there. You'll also be provided with some of the materials from the webinar today. The recording of this webinar is going to be posted on the webpage shortly, along with Q&A, which is coming up now. And finally, we invite you to share the link with anyone you know who could benefit from it. Now, remember, anybody with any interest in coastal fishing or anything related, as well as internal bodies of water in Canada, so rivers, lakes, canals. Okay, questions. So we've received a number of questions already. I've got them here. So by all means, submit your questions now. We've got about 8 or so minutes to get to them. I don't think we'll get to them all, but certainly we'll be able to answer some of them in writing. Okay, so our first question here. If a spill release is above or upstream of the loading flange, okay, is it a land-based spill and the responsibility of the fueling station, yes or no? So it sounds like what we're describing here, and this question is from Stafford Reed. If the release is upstream above the loading flange, I think we've already addressed this. This sounds like a shore-based spill, and it doesn't sound, unfortunately, as if the Shipsource Oil Pollution Fund could issue compensation here. Okay. We've got another question here from Travis Hall. How many years can a claim go back? Many are not aware of this fund. Okay, this is where our time limitation periods come into play. So again, in most cases where there's been an oil spill, you're looking at 2 years from the date of the incident, or realistically the date the damages were sustained. Alternatively, well, if you're going to go direct to the fund, you've got your 2 years. There is an extra year available in the case of a spill if you're willing to pursue court action against the owner of the ship, in which case the fund becomes involved in that indirect capacity. So up to 3 years following the incident. If there is no spill, or if there's an incident and then a spill a little bit later, you might have up to 5 or potentially 6 years. 5 if you go direct against the fund, and 6 if you go against the polluter in court, as well as the fund in the indirect capacity. So hopefully that answers your question, Travis. Okay, we have another inquiry here from Mr. Hall pertaining to the deadlines. Let's see, we've got, if your organization has not informed the community directly and they receive your info after the fact, they should be able to apply because your organization has not given the info to the people affected. This is unfair because the info is not spread by many indigenous communities. Okay, absolutely. This is where hopefully the 3-year time limitation period will be beneficial. I'll stress actually that the special claims mechanism is based on this concept to a degree of discoverability. So let's imagine a circumstance where there's a spill, but the people affected are not necessarily aware that they have been affected by the spill. It's possible in those circumstances that additional time may be available to claimants to submit their claims. We would encourage you to look at our special loss claims manual. Okay, here's a really interesting question as well. How do you calculate financial compensation for subsistence harvest or livelihood loss? This is a very interesting question, of course. The two concepts don't necessarily line up naturally. We have to acknowledge that. Though subsistence is economic in a sense, there's also a cultural dimension to it. So here's an example for you to consider. Let's say your community depends on fishing for subsistence. Well, if the community is no longer able to obtain the products that it would take from the sea, we would compensate like for like, essentially. So replacement of fish or other marine produce, for example, on a cost-to-cost basis. If you're fishing sockeye salmon, we would likely consider compensation that would replace that sockeye salmon, whether you had to purchase it or find it somewhere else. So the actual cost associated with obtaining that replacement would be compensable, again, to the extent that it's reasonable. But that also applies potentially to cultural losses. I mean, in small communities, it's obviously very important, small or large communities, it's very important sometimes that fishing and traditions be passed on from generation to generation. Well, if you're looking for an alternative, let's say it's not safe to extract fish and other marine products from a certain area, if you're looking for alternatives to ensure that that tradition carries on, and you look to other fishing grounds, the cost associated, the over and above costs associated with reaching those different grounds could be compensable from the fund. Okay. Any other questions? Okay, we've got a question from Tyson Carswell. In definition of vessel, okay, let's see. Definition of vessel that includes barges. Can aquaculture net pens fit that description? Okay, great question. We've seen this in the past. A couple of times we've been faced with this question. We've got to emphasize that in order to be a ship, a thing or a facility would have to navigate. And this can be a complex legal question. It's a question of jurisdiction in many cases. If there's an inherent ability and design that incorporates navigation, so a barge, for example, is designed to navigate. The purpose of a barge is to move around and to transport goods, generally speaking. It's pretty clear that a barge is designed and does navigate. But a dock or an aquaculture facility, for instance, it would depend on the degree of portability and navigability of that structure. So hopefully that gives you some assistance. It's a tough question. It's very fact specific. It would be informed by all the details of the given structure or vessel. Okay. I think we may have some more. Yeah. Okay, I'm just going to pull open. Okay, let's see. Do we have any more?
It's a longer one.
Okay. So I think we're getting close to the end here, but by all means, if you have more questions, submit them. If we're not getting to them, we will definitely answer them after the fact in writing. Okay, I understand there's one long question. Let's see. Let's see. We're going to get it on another screen here. Okay. Okay, very quickly, I'll try to read this question. How does the SOPF administrator reconcile what is required in its special claims manual and what actually occurs in a First Nations coastal community as explained below? Based on a 2016 University of British Columbia study, let's see. Coastal Indigenous people eat 15 times more seafood than non-Indigenous people. There are more than 30 kinds of food harvested. Making a claim for loss or reduction in subsistence harvesting would be problematic for a coastal First Nation, as each person must account for their harvesting and then seek alternative resources. Okay, so I noticed that the question is very long. I'll try to address it in part before we close down here, but essentially what we're looking at here, at least the first part of the question, deals with the potential for a communal claim. A communal claim may not necessarily be possible. However, it's possible to submit a thing that looks like a single claim so long as it identifies individual constituent parts or individual persons who have suffered as a result. So a community could conceivably submit one package to the fund, a bundled claim, and we discussed this a little bit in our special claims manual. A bundled claim in which it would be captured sort of a communal loss, and then there'd be some form of evidence indicating the individuals who were affected by that communal loss. So this is something we can respond to in more detail in writing after the fact, but we better end there given that we've gone a minute or two over time. So thank you everybody for your participation. Be sure to check back on our website and watch your email for further updates. Until next time, stay safe and stay healthy, and thank you so much for attending.